Good morning and welcome to the Supreme Court of the United Kingdom. Today is the third day of an appeal in judicial review applications by Margaret McQuillan, Francis McGuigan and Mary McKenna concerning the duty to investigate under Articles 2 and 3 of the European Convention on Human Rights. And we are hearing at the moment the submissions of Mr. Hugh Southey QC, whom I will now invite to continue his submissions. Mr. Southey.
Thank you, my lord. Can I just deal with a couple of sort of preliminary things? Firstly, we've had some discussions. Obviously, I started late yesterday because the appellants slightly overran. The proposal at the moment is, subject obviously to the court's approval, is that I started roughly 15 minutes late. I will finish 15 minutes late, as will Ms. Quinlivan. She will also finish 15 minutes late, and that will attempt to catch up during response, effectively during replies. So that's, as I say, the proposal from the parties. Secondly, I'm finished yesterday with the Human Rights Act. Inevitably overnight, in discussions with my team, there are one or two things that perhaps we wanted just to mention before finishing the submissions on the Human Rights Act. The first is this. There were some submissions from Mr. Cole in particular about sort of the volume of potential claims if the Human Rights Act were to apply, as we argue it. Can I just make 2 points about that? Firstly, one has to be very cautious about the implications of the application of the Human Rights Act for example, litigation in Northern Ireland, or rather drawing any conclusions about the implications. For example, there was reference to a number of outstanding civil claims, but it's very unclear how many of them will be affected by this ruling, because most of those are about substantive breaches of the law during the period of the Troubles. And of course, nobody suggests that the Human Rights Act applies to substantive incidents that occurred during the Troubles. So one has to be very cautious about, for example, how many of the civil claims will actually potentially change or be altered in any way by the findings of the court or the ruling of the court about the applications of the Human Rights Act. What is more significant, obviously, is the point we made before about any finding that the Human Rights Act, for example, limits claims such as these, will not prevent litigation in Strasbourg. And one of the points that we've made in our written pleading, but would wish to emphasise in relation to that, is, of course, one of the advantages of this litigation is that it will give this court the opportunity to, and indeed the Northern Irish courts, the opportunity to comment on issues of independence. Had this litigation been forced to go directly to Strasbourg, one would have had the Strasbourg court ruling on independence, an important issue, as you've heard, without the input of domestic judges. And that raises a question about the intent of Parliament. Second thing I didn't directly address and should have done was the question my Lord Sales raised, I think, on the first day of the in relation to the appellants. And he asked about other convention rights, raised the question of breaches of other convention rights that continue to have consequences. The fact a breach of a convention right has consequences are, in some circumstances, many years after the breach, doesn't mean it's enough to bring it within the terms of the Act, even on our argument. And the reason for that, quite simply, as was made clear in this court's judgment in Johnson, which we can provide a copy of if need be, it's 2016, it's paragraph 28, is that you don't have a continuing breach of the convention simply because there's a continuing effect. Continuing breaches of the convention require continuing activities. So one would still need acts in relation to other convention rights after the commencement of the Human Rights Act to bring them within jurisdiction. The only issue essentially the issue that arises in this case, of course, is that you have a detachable right and you do have acts taking place after the commencement of the Human Rights Act. And that links in to our fundamental concern, which remains essentially that if one is going to sort of impose some sort of restriction which isn't reflected in the terms of the legislation, because of the concerns essentially about retrospectivity, in our submission, unless that's expressly in the legislation, that ought to be a matter for Parliament, because there are arguments, policy arguments on both sides. The reality is, in our submission, that Parliament couldn't have sort of envisaged the sorts of restrictions that are essentially argued for by the respondents, by the appellants rather. The final point I should just touch on briefly is I mentioned that briefly, because it isn't our primary submission, I accept this, that if we were wrong about the need for genuine connection, the approach of the Court of Appeal in McQuillan to genuine connection should be followed, because it reflects effectively domestic policy considerations. One thing I should make clear about that is obviously we would say that if that approach had been properly followed in the hooded men, there should have been found to be a genuine connection, because in our submission, firstly, Brecknell would have been present, and secondly, the critical point here, which is the importance of a criminal investigation in relation to responsibility, clearly didn't take place in the 1970s. And so the key issue for Article 2 purposes, which is the criminal investigation, remains outstanding. Can I then go to the issue of independence? And in contrast to my learned friend, Dr. McGuigan, what I'd like to do first, if I may, is start by looking at the legal test. And the reason in my submission that's appropriate is because in our submission, there is no error of approach in the Court of Appeal. And in those circumstances, the Court of Appeal's judgments in relation to independence should be respected. A couple of points I should make about that. Firstly, I've referred to the judgments. There was a certain amount of debate about what the Court of Appeal actually decided in the hooded men case. Our submission in relation to the hooded men is that the Court of Appeal ultimately in paragraph 116 Roman 9 didn't make a final decision about independence, but expressed concerns about it, and expressed concerns that were not just about the institution. There was an express reference to the previous investigations, taking account of the history of the matter in the same way that they took account of the history of the matter in the McQuillan case. That approach, and in one sense, perhaps I over-compressed our position in relation to this a moment ago, reflects in our submission the findings of Mr. Justice McGuigan. I particularly asked the court to consider those paragraph 283, electronic 2026, where he did find a lack of independence, and he found a lack of independence for reasons that included matters such as the investigative failings in the past as he found them. And in our submission, there is no basis for reopening those findings. And I say that, and this is the second starting point, for two reasons. Firstly, the general point, which is the point I think Lord Hodge made on the first day, which is this is an appellate court, this is a court as a result that should be cautious about reopening findings. But secondly, and more importantly, we've drawn attention in our written case to the judgment of this court in Berkeley, which is again, we'll give you the reference, I won't take you to it now. It's electronic 6699, a case which was about the appropriateness essentially of bringing judicial review proceedings in England in relation to Guernsey. And at paragraph 39, this court made it clear that one of the reasons why the proceedings should have been brought in Guernsey was that Guernsey was in a much better position, infinitely better was the language used, to assess the independence of its courts. And that's an important point here, is that the vast majority, or the majority of Northern Irish judges who have looked at this, a significant number of Northern Irish judges who've looked at this, have concluded that there is an issue here. And in our submission, that local judgment it's something that should carry very significant weight. Turning then to the approach, my learned friend drew attention to the judgment of Jordan, and Jordan is a useful example in our submission of the approach that the Strasbourg Court has adopted to independence and the procedural obligations generally in the context of Northern Irish cases. And my learned friend drew attention to the reference to hierarchical, institutional, or practical independence, which is at electronic 5168, paragraph 106. But that in our submission, in one sense, doesn't help one very much necessarily, because it's not a test. It's effectively a description of the routes by which a problem with independence might arise. What we would draw attention to is two things in relation to the approach in Jordan. Firstly, as a matter of general principle, see page 5169, electronic 108, the court clearly expresses concerns about the need for public confidence, essentially, in adherence to the rule of law, etc. And one sees that in paragraph 108 in relation to prompt response. But that then feeds in, and this is the second point, to the approach to independence. And what's telling about that is the approach to, as I say, the independence of the investigation. If one goes to electronic 5172, paragraph 120, the court looks at the position of the RUC, finds a hierarchical link, essentially, finds effectively an issue there. It then goes on, and this is perhaps the more important point, to consider the role of the DPP. And at para 122, it notes that the DPP is independent, and re-emphasises that at para 123, but then puts that in the context of, or then links that rather to the police investigative procedure, and noted that that was open to doubt. And it says, in light of that, it is of increased importance, this is the second sentence in para 123, it is of increased importance that the officer who decides whether or not to prosecute also gives an appearance of independence. Looking at appearance, it picks up on the fact that there were no reasons given by the DPP, and indicates that means effectively that the decision isn't conducive to public confidence, the next sentence. Picks up that again at para 124 and indicates that there was nothing essentially to reassure a concerned public that the rule of law had been respected. So one sees there in my submission the court linking a public confidence essentially to issues of independence. Now, how does that relate to Tunk, that obviously forms a very significant part of the appellant's arguments? Tunk, the key statement of principles, we accept. Sorry.
Oh, sorry, Mr. Stovey. Just on paragraph 124,
yeah,
what the court seems to be concerned about is that there was no reasoned decision available to explain why the shooting was not regarded as disclosing a criminal offence meriting prosecution. Wouldn't that be something that would be available at the end of an investigation, and hence capable of giving assurance at that stage that a proper investigation had been carried out?
Well, our position in relation to that is perhaps as anticipated, is that although Strasbourg quite often is considering a case at its end, if one's in a situation where, to apply the approach of the Court of Appeal, one can see at the start that this is not going to inspire public confidence, paraphrasing, but hopefully not too badly paraphrasing the appropriate test, the court in our submission must at that stage be able to intervene. Of course, the particular issue arose at the end, but the critical point I'm relying on is the fact that the court is linking issues of independence to public confidence effectively.
But here the court seems to be thinking that if there is a full report at the end, that may be capable of securing public confidence. And you don't know at the start whether you're going to have that or not. But
it's obviously in the circumstances of the particular case, in that one's looking potentially there at a very different situation to the situation here, where, as I've already emphasised, in both cases on the findings of the courts below, you'd already had findings by not just the RUC, failures by not just the RUC, but by PS&I.
Yes, thank you.
Well, going back, as I say, moving on to Tunk and how one links this to Tunk. Tunk, the key passage starts, we accept, which is where the court sets out its principles, at para 217, which is electronic 5412. Para 220, it recognises the approach isn't exactly the same as to a fair hearing, but recognises that the requirements of a fair hearing made, to use the language of Strasbourg, inspire the approach to procedural issues. The distinction essentially that is drawn in our submission between para 221 and 222 is between Article 6, where the focus is very much, in many cases at least, on effectively the terms of appointment of judges, etc. And what happens in relation to Article 2, where there is an examination of the investigation in its entirety, to use the language of Strasbourg, which takes account, for example, of both what might be described as structural issues. So the judgment identifies examples of cases where there were direct colleagues involved, hierarchical relationships with potential suspects, specific failures, and that's where we would say the history of the investigations in these two cases potentially becomes relevant. Failure to explore certain lines of inquiry, again, highly relevant in the circumstances of this case, and excessive inertia, something which potentially was an issue also in McQuillan, because ultimately one of the problems in this case was that if the PS&I had taken over, and we'll come on to the evidence of this, the commitment was essentially for the case to be considered in accordance with the case. Sorry, the issue was whether the case should be considered in accordance with the case sequencing model, something you've heard about, which may mean it would have been considered many years in the future. And one doesn't know how long it would have taken to investigate the McQuillan case, because it would have gone in the queue at some point, which was unclear. So the inertia was also potentially an issue in this. But what the critical point about 222 is, in one sense, like Porter and McGill, it says take account of all the circumstances. Now, my learned friends, particularly Dr. McGuigan, place significant weight then on para 223, which talks about the need for sufficient independence. But sufficient independence, of course, is not a test. It merely says there needs to be sufficient safeguards, sufficient arrangements in place to ensure independence, but it doesn't say how you assess sufficiency. That is important because in our submission one comes back to effectively Porter and McGill, because Porter and McGill is the only test that generally is applied in this context. That is then followed by para 224, which makes the point that where there is an institutional issue, then one needs stricter scrutiny. And that, in our submission, is consistent essentially with the approach that was adopted by the Court of Appeal, which was to look at the institutional issues and then look at what had actually happened, essentially. But what then finally is made clear in this judgment is that there is a relationship essentially between independence and investigation, and one sees in particular at the end of para 225 it said it is in relation to the purpose of an effective investigation that any issues including independence must be assessed. I'm going to come back to that in a moment. Can I just make one other point about Tunk before moving on? There was a certain amount of reference to what actually had happened in Tunk. One of the things, though, that one needs to be cautious of, because it is clearly identified as being relevant to independence, is 255, which is where the European Court makes the point that Tunk, although it was a case involving soldiers, was not a case where there was an issue about the security forces as an institution. In other words, what was an issue in Tunk effectively seems to be normal criminality that happened to be committed by a member of the military. Here, in the Hooded Men case, very obviously there is an issue about the institution, because what was an issue is not simply aberrant misconduct on behalf of individuals. In relation to the McQuillan case, once one gets to the point, as the court did, that there were potentially non-benign reasons for, I think that's the language used, for failing to investigate the role of the security forces, one again has issues about the institution, because one issue that potentially arises is what the motivation was for not investigating the role of the security forces. Now, a moment ago, I drew attention to the reference to effectiveness, and in our submission, Tunk should be read with the line of the other authorities, essentially, particularly Grand Chamber authorities dealing with independence, particularly Ramsahai, because Ramsahai sheds light on what is meant by effectiveness in this context. So if one goes to electronic 5308, page 325, sorry, para 325, page electronic 5308. One sees the court set out what it has done before, which is the requirement of independence, but the court clearly indicates that that independence is needed for the investigation to be effective, and the reason why that is required is because public confidence on the state's monopoly on the use of force is an issue. Now, whether Tunk was genuinely a case of that nature might be open to debate, but these cases clearly are cases where what is in issue is the state's monopoly on the use of force. And that suggests, at least in this context, effectiveness depends on there being independence, because without effectiveness, the objective essentially of ensuring that public confidence is maintained is undermined. And so one sees there the linkage essentially between effectiveness, public confidence, and independence, which in our submission is unsurprising, because clearly if the results of an investigation are presented by a body that the public has legitimate or the fair-minded bystander is perhaps a better way of putting it, has legitimate doubts about, then that isn't going to satisfy people that the rule of law has actually been complied with. Should say, and I won't take you to it partly because of time, but Strasbourg since Tunk has continued to make reference in the context of independence to appearances, and an example of that, example we rely on of that, is apostle, which is electronic 10251 paragraph 33. Now, my learned friend Dr. McGuigan accepts, consistent with this, essentially, that public confidence has a role to play. But he says it's not the test. But that's not the approach of the Court of Appeal in our submission. If one goes to the Court of Appeal's judgment in McQuillan at 265, electronic 265, para 156 and 157.
Could I have the page number again, please?
Sorry, 265, my lord.
Thank you.
What one sees there, particularly in start of 156, having set out essentially both the requirements of Strasbourg in Ramsay, the line I cited a moment ago in 153, and the approach in Porter and McGill in Lowell. At 156, the court is noting effectively that the objective essentially of Ramsay is public confidence. The objective of Porter and McGill is public confidence. And so that there's no, what the court is essentially saying is that in those circumstances, there's good reason why Porter and McGill should have informed the approach to independence in this context, because they're both concerned with the same thing, public confidence. And that is clear in our submission from Lowell. If one goes to electronic 6293, paragraph 14, this is the judgment of the House of Lords, I think, in fact, in Lowell. Paragraph 14, the court set out, Stein delivering the judgment on behalf of everybody, Porter and McGill, the key passages from Porter and McGill and the Porter and McGill test. But what Lord Stein then goes on to state, having cited Porter and McGill, at electronic 6294, is that the reason for the Porter and McGill test, essentially, slightly paraphrasing, but hopefully appropriately, was that the reason for it was that the core need for confidence, which must be inspired by the courts in a democratic society. It's the first two lines, essentially, first three lines, and 6294. Now, one can transpose that language in our submission into the Article 2 context. The reason for the requirement for independence, essentially, is the need for confidence to be inspired by the process. And that linkage, it's not just the Northern Irish Court of Appeal that's made that link. The English Court of Appeal has also made that link, in particular in Musa, which is electronic 4333. Paragraph 35. Halfway down the page, halfway through paragraph 35, starting with the word secondly. leave you to read that. But that's essentially paragraph 35 there is where the court is adopting the need for the approach in Lowell. It's adopting it essentially because of the need to inspire public confidence. And we submit that's entirely consistent with Strasbourg authority about the importance of public confidence. Now, in our submission, in the UK context at least, it would be quite surprising if Porter and McGill was not the applicable test. And I'll give you a number of reasons for that. Firstly, it's clearly been recognised in domestic law that Porter and McGill is a test that is sufficiently flexible that it doesn't simply apply to judicial functions. The example we've given of this is the House of Lords applied it in Reed-Duffy, Electronic 4661, to the Northern Ireland Parades Commission, not to an individual. Distinction my learned friend Dr. McGuigan sought to draw between individuals effectively involved in an investigation and bodies isn't supported by this, because clearly Lord Bingham in particular looked at the Parades Commission as a body. But it is clear in that context, see Lord Carswell paragraph 49 and 50, that Porter and McGill was applied. So it is flexible enough to be applied to bodies that are not courts, where independence is required. There are other examples, a number of examples effectively, and but Duffy is perhaps the one from this level. The second reason why it's not surprising is the point it reflects on. It's based on Lord Reed's judgment in Osborne. And Lord Reed makes the point in Osborne, see Electronics 6882. Lord Reed makes the point in Osborne, paragraph 55, that one of the problems with the convention is that the convention is often expressed in, to use his language, high levels, very high levels of generality. And it's national law that is more specific. And of course, Porter and McGill are not just essentially what is imposed by Article 6, but it is also our domestic common law test of independence. See, for example, Duffy, which I've just been to. And on the basis of this, I think the Lord Leggett's has a question.
Sorry, I was waiting to be unmuted. Surely Porter and McGill is narrower than independence. It's concerned with impartiality. Lord Hodge gave the example yesterday of arbitration, where in some systems the arbitrators required only to be impartial. In others, it's required to be impartial and independent. So independence is wider. You might say, for example, that if counsel in the arbitration comes from the same chambers as the arbitrator, that doesn't cast any doubt on the arbitrator's impartiality. It wouldn't make the person suspect a real possibility of bias. But a system which requires arbitrators to be independent might consider that to be a link, which meant that the arbitrator wasn't wholly independent. So surely independence is a wider concept than impartiality. And this is just a narrow aspect, the Porter and McGill test, if you like, talking about the possibility of bias. When there's a possibility of bias, it's a fortiori.
Well, sorry, I should be clear. I'm not saying that Porter and McGill is the only way in which one could challenge, for example, a lack of independence in relation to an investigation. What I am saying is that the Court of Appeal is entitled, in the circumstances of this case, to apply Porter and McGill, because if the Porter and McGill test is not met, then, as my Lord says, I think, a fortiori, there's a lack of independence. But that's not necessarily the only way in which one could establish a lack of independence.
For what it's worth, I mean, I didn't read the Court of Appeal. I read them as applying it historically to and the judge to the previous investigation, and saying that there was a real possibility of bias. And in the light of that, that has relevance for what should be done now. I didn't read them, or you may submit otherwise, as saying that there's a real possibility of bias at the moment in the present investigation.
I think that's fair. I mean, I think I might use slightly different language, but I'm not sure it comes to any significant difference in that I think the passage I just took the court to indicates they regarded it as a potential tool in certain circumstances, but they weren't necessarily saying it is identical to the Article 2 test, effectively. And in fact, they were quite clear about the need to focus on whether there was a practical independence.
Thank you.
What I would say, though, also, my Lord, in fact, I think put this to my learned friend yesterday, is that and it links back to the Osborne point, effectively, and it's consistent with the point I made, which is that effectively, if you can't meet the Porter and McGill test, then there is a problem. Ultimately, because Porter and McGill is, if you like, the domestic test, it's very difficult to see how applying the Strasbourg language of the importance of public confidence in those circumstances, an investigation which doesn't meet the domestic law on independence could satisfy public confidence. A couple of other things I should say about the test. Or the approach of the Court of Appeal. My learned friend, Dr. McGuigan, took issue essentially with the reference essentially to lack of information. When asked why more information couldn't have been given, he said it was because of litigation. But clearly, in many respects, as one sees in this court, there is no reason why more information couldn't be given. There's no reason why, for example, as this court now sees, the court couldn't have been told, we've made arrangements for an English police officer to come in and conduct an independent investigation. Effectively, what the position was, we would say in both Kelly and Hackett. But in any event, in our submission, if those concerns are raised, the sorts of concerns that were raised in this case, in our submission, a failure effectively to engage with them is something that is relevant because it will concern, for example, the fair-minded bystander, if that is the correct test. And in that context, it is relevant that the Belfast Agreement, which my learned friend places very substantial weight on because of pattern reforms, emphasises the need for openness. And so it is legitimate in our submission for the court to say it is unsatisfactory for us to be put in a position where there are legitimate concerns and we don't have an answer to them. And that's really what the court was saying, particularly in circumstances where openness has been recognised as independence. And that is, we would say, also consistent with Tunk and what Tunk said about the need for particular scrutiny where there are question marks out over, for example, the arrangements that have been made within an institution. If I'm wrong about the approach and there is a need to reopen findings of fact, There are some principles we would submit that are also relevant and that the court needs to take account of. Firstly, and it in some senses also links into the approach the Court of Appeal took, it is quite clear in our submission that it is legitimate for a court assessing independence to look at the failings that have occurred in the past. That is the approach the Court of Appeal took, and that reflects the approach in Nachova. My learned friend referred to Nachova. It's an electronic 5210, tab 20. Sorry, I'm the only person using tabs. Electronic 5210. Para 112 is where the court refers again. It's again a Grand Chamber decision to the importance of independence. But going over the page, the European Court at para 115 to 117 looked at the failings, investigative steps not having been taken, relevant facts having been ignored, expressed that and indicated that that was a matter of grave concern because it cast doubt on impartiality, and again linked essentially that impartiality to the effectiveness of the response and also to public confidence. And so one sees in paragraph 117 this coincidence that I've already highlighted, or this cross-referencing really that I've already highlighted to impartiality, effectiveness, and public confidence. And that in that context, the court is quite clear that failings in the past are relevant. And as I say, in both cases, in this case, the court referred to failings. Two other matters that we would submit are relevant if the court is going to review human rights, independence rather again. Firstly, the seriousness of the violation that's occurred is important. Al-Nashiri made it clear, I won't take you to it, it's electronic 5969, paragraph 641, that where there are particularly serious human rights violations, there is a right to truth, and that, again, that exists in part, we would submit, because of the importance of maintaining the public confidence. And secondly, that sort of principle, well, the general principle that there needs to be effective Article 2 investigations is particularly important in post-conflict societies, which we would submit essentially is what the position is post the Troubles in Northern Ireland. And the reference for that is Jellic 8599, paragraph 78, 94, where the court noted the sensitivities of issues relating to the conflict at the start of the period of Croatian independence, but indicated that sensitivity and that importance made it particularly important that there was an effective investigation. Now that's the context of the submission I'm about to make about the position, the factual position. And as I say, our submission is one doesn't need to get into the facts because the Court of Appeal's findings should be respected, but given obviously the submissions that have been made, it's important to understand the factual position. The starting point in our submission is that it is quite clear that there are serious issues raised about the conduct of members of the RUC during the Troubles. In one sense, the most obvious example in these cases is what happened in the Hooded Men's case, because there's no doubt the RUC was, as an institution, involved in that. There is other examples in the papers of allegations of collusion, findings of collusion, essentially. I'd refer in particular to the report of Muslundi, the academic you've already heard reference to, at page 873, where she refers to the Operation Ballast report in relation to collusion between the police and paramilitaries, loyalist paramilitaries. And in response to the written case of the PSNI, there is additional evidence, if that's admitted, from Mr. Omorohu at page 10342, paragraph 8, which sets out further findings of various investigations in relation to collusion. Now that's important because PSNI, as the Court of Appeal found, it is not an entirely distinct organisation. The Court of Appeal at para 188, page 280, recognised that the RUC hadn't been dissolved but had been retained with new oversight arrangements and a new name. And that's also reflected in the fact that there are staff still employed who have RUC service records. And perhaps because of that, one of the missing documents that was before the court below was evidence that, for example, the former Assistant Chief Constable had talked about not disassociating himself with the past. That's missing document page 3, if I can refer to those documents in that way. Now that's the context of what has subsequently occurred, because in our submission, what has occurred was that once the trouble started to be investigated, initially there was a recognition that presumably because of that sort of history and because of that sort of controversy, there was a need to put safeguards in place. If one looks at the Lundy report, the first Lundy report, which is electronic 873, the relevant passage, she refers to how the and this is really essentially at the first paragraph, how because of concerns essentially about collusion, the PSNI had established within the HET what was described as a white team. And they'd done that in part because of concerns, as I say, about the need to deal with collusion cases and the concerns about the European Court of Human Rights. There's further evidence of that in the supplementary bundle at 292, which is a presentation to the Irish Parliament, which effectively is what is relied upon by Ms. Lundy. But on seizing Ms. Lundy's report a summary of the position, which was essentially there was a need to deal with collusion. So a white team was established. Now, that white team no longer exists. There is no specialist team essentially outside Northern Ireland as far as we're aware. And that's consistent essentially with concerns expressed by both the Court of Appeal and Mr. Justice Tracy at first instance in a case called Barnard that I'll come to, which is that safeguards that were initially put in place to ensure independence in relation to Trouble's investigations have been effectively dismantled. Now, Ms. Lundy made two criticisms essentially in that first report, which was in 2009, if I remember rightly. Firstly, at page 888, she was criticised. She criticised, rather, at least noted, that there was the intelligence, the management of intelligence was by former RUC officers. Now, I draw attention to that in part because that has been a consistent theme, that one of the problems with investigation is that intelligence has not been handled sufficiently independently. And that is a problem that's picked up by the Chief Inspector, a problem that continues to, in our submissions, cause concerns. She also indicates in that context that intelligence isn't equally available. Essentially, it's more widely, it's more accessible in relation to incidents involving paramilitary groups. She was also critical of the fact that there was over-reliance on RUC corporate memory, and that's at 912. She then produced a further report, which it is fair to say was focused on military, but in some senses that it's a particular concern, given it wasn't particularly about RUC incidents. It suggests that there may be particular concerns whenever the state apparatus is in issue. And the concerns she expressed essentially were that there was an inconsistency between military and non-state cases. And it's that led to the Chief Inspector's report. Now, we would highlight in relation to the Chief Inspector's report actually three findings, which are not necessarily the same as Maloney Friend. There are the two that Maloney Friend highlighted. At page 994, there was this continuing concern about the management of intelligence. It should be noted that that concern, if one's looking at it at 994, that concern, that's more importantly, the first line of 995, is that intelligence is accessed through PSNI's intelligence branch, C3. That's reflected also in 996, where there is reference to the involvement of both former RUC and PSNI officers in the intelligence process. And that's important because in our submission, the problem that one still has, as recognised, essentially, even in the evidence, essentially the late evidence that's been submitted, is that one still doesn't have external control, external to PSNI control over intelligence. And the second concern that was raised by HMIC was that essentially there was an insufficient vetting. It was of officers who were involved in HET investigations. One sees that essentially as 1017 onwards. They're the two concerns that essentially Maloney Friend emphasised, but there is a third concern that, given the current position and the evidence that's been submitted, is also important to note. The Chief Inspector was clearly concerned about the capacity of HET to actually conclude its investigations. So it looked at page 939 at the number of cases that were being concluded per month and expressed concerns that there was a potential need to look at funding. That was recommendation 9. Now, I emphasise that because, as Maloney Friend accepts now, unsurprisingly, in light of the current evidence, he accepts that the reality is that the investigation of the Troubles is not likely to conclude for many years. And that links in with the Tunk point, that one of the factors potentially to be considered in terms of independence is delay. Because if one has delay, it undermines public confidence. And the reality is, as I say, that despite, if you like, the concerns of the HMIC about delay, the situation has got worse. And one of the reasons why the situation has got worse, quite clearly, one goes to 1058. Following, as my learned friend pointed out, following the Chief Inspector's report, HET was replaced by the LIB. The explanation given in this letter from the Chief Constable is essentially that there'd been a need to close HET because of budget cuts. And it was recognised that LIB, as a result of the budget cuts, would work at a slower pace. And that, consistent with that, the Chief Constable in 2015, a couple of months later, January 25th of January 2015, page 1118, bottom of the page, indicated that LIB is not adequately staffed and resourced. So if one thinks about the case of McQuillan, what essentially PSNI were proposing was that they would take over the investigation despite their historic failings, and I'll come on to those in a minute. They would investigate them through the LIB in circumstances where the LIB they accepted was short of resources and might well not be able to undertake the investigation for many years. One doesn't know where it would have fallen within the sequencing model. Indeed, there's recent, albeit leave authority in the High Court in Belfast, indicating one isn't entitled to know where in the sequencing model one falls. So,
Mr. Sully, to whom is this letter addressed?
It is, if one goes to the end of the letter, it's 1121, the policing board, the chair of the policing board.
Thank you.
And that's the context of Stormont House. I mean, what happened with Stormont House in our submission is that Stormont House recognised that there was a problem with the current arrangements. I mean, the pattern reforms were not specifically concerned with the legacy. There's no reference, effectively, to the specific challenges. One sees then a recognition that there's a problem with the legacy because of the white team. But once the organisation comes under pressure, for a number of reasons, and once it's challenged, essentially, it becomes clear that other arrangements need to be put in place, and that's why Stormont House essentially proposes includes an agreement effectively for a new arrangement. Of course, that hasn't occurred. What one has in the meantime is that where litigation has been brought, as in the McQuillan case, where there is a particular political sensitivity, as in the Canova case, which is about the investigations into steak knife, specific arrangements are put in place to bring in external officers. There's no suggestion they don't have public confidence. Where the public confidence issue appears to be, we would submit for good reason, given the issues that I've just highlighted, is in relation to PSNI's arrangements, in particular the arrangements in relation to the LIB. So the idea that the LIB is a new start, effectively, and should be given a new chance in our submission is not realistic. And that's also reflected in the second report of the Chief Inspector. And the Chief Inspector essentially looks at the arrangements in 2015, expressed concerns about budget cuts. One sees that at page 1185. paragraph 2105, again suggests there's a need to consider essentially how long outstanding cases will take to determine. At that stage, it was thought essentially that the cases could be completed within 5 years. Of course, that's proved far from possible. Expressed concerns about the independence still of intelligence. One sees that 1189, 2128 in particular. It identifies actually 2127 to 2129, 3 problems with it, but in particular at 2128, the need for someone to be independent of C3. And again, expresses concerns about vetting. In fact, there'd been no procedure for vetting. 2198 onwards, essentially, page 1199. Now, what it also did was 2 other things. Firstly, it looked at compliance with Article 2. And in our submission, reached a pretty clear conclusion about there being an issue in relation to Article 2 at paragraph 413 to 415, where it noted that for Article 2 purposes, there needed to be an independence, and expressed a concern about guaranteed independence from those involved in the initial investigation or events, and indicated essentially that you needed vetting for that, and expressed concerns again about intelligence. And the Court of Appeal, the approach of the Court of Appeal in relation to this in the McQuillan judgment was to indicate that in terms of the intelligence being verified outside Northern Ireland, and that's where the focus of the Court of Appeal was, it's paragraph 62, page 241, there was no evidence that it was verified outside Northern Ireland. That emphasis on outside Northern Ireland in our submission is not surprising, given the reports of the Chief Inspector, which expressed concerns effectively about whether or not people from outside Northern Ireland were involved, expressed concerns about PSNI's involvement. It didn't really essentially make a conclusion about verification, in part because what its focus was on, and I'll come on to that in a moment, was about the point I made before about the changes that had occurred since the Committee of Ministers review. And it noted essentially verification hadn't been present at the Committee of Ministers, but it equally recognised, which is an alternative way of dealing with the problem of verification, essentially, that one of the arrangements that had been in place at the time of the Committee of Ministers, which was no longer in place, was the White Team, and it recognised that at para 54. And we don't accept that Mr. Wright's evidence is admissible, but to the extent it is, what Mr. Wright says, 1670, para 20 to 21, is essentially it's a PSNI officer who is managing intelligence. And para 30, his evidence essentially again indicates that conflicts procedures depend essentially on self-declaration, and indeed at page 1338, he produces the new policy on conflicts of interest, which only requires or only gives senior management the power, essentially, or it refers to it being possible to access in original investigative material. It doesn't require that material to be accessed to check conflicts of interest. And of course, all of that's in the context of a situation where the capacity is far reduced. Sorry, my Lord Legate, I think, has a question for me.
Sorry, it's just information. I haven't entirely understood what the report is that you've been taking us to.
Sorry, my lord, I've been going quite quickly.
What its origin is.
The report, I think, I think, my lord, it's the, my learned friend referred to it at all. It's the chief inspector was initially brought in by.
Who's the chief inspector?
The chief inspector of constabulary, who's a statutory statutory inspector of police, essentially, who is brought, who in the Northern Irish context can be brought in by policing authorities, essentially, to review efficiency and effectiveness. Is that, my lord, if one wants a sort of reference at the start of the first report, page 931, there's an executive summary which sets out both generally what the chief inspector's sort of position is as a matter of statute law, and also why they were particularly brought in to look at the HET.
Thank you.
And what I should also emphasise, and I think because I'm just conscious of time, is that the second report, although it was essentially a follow-up report, and so initially was focused on the HET, it did specifically look at the LIB, and in fact indicated that the LIB was a step backwards, and I should have emphasised that. It's page 982, paragraph 4.23. Which is where it talks about how the HET was essentially only institutionally linked with the police PSNI through reporting to the chief constable. The LIB was less independent. And that's essentially the concern. You've also heard reference to the Joint Human Rights Committee. I won't take you to that again because of time, which is at 1132. That was essentially the concern picked up by the Human Rights Committee. Now, what the Court of Appeal focused on was what had occurred since the Committee of Ministers. And I should say, and come back to the Committee of Ministers in a moment, what the Committee of Ministers are doing, because that's of some significance as well. But obviously, my learned friend placed a certain amount of weight, essentially, on the Committee of Ministers and its sort of conclusions reached in about 2007, 2008. The Court of Appeal, and this is our submission of importance, looked at what had occurred since the Court of Appeal, since the Committee of Ministers had closed their initial consideration, essentially, of the investigative arrangements. And it identified a number of ways in which the safeguards of independence had been undermined. And that starts page 235, paragraph 35. And this is important in many respects because it undermines two key points of my learned friend submissions. Firstly, the idea that the LIB is a significant development because it's looking at the safeguards in place in relation to the LIB as opposed to those in place at the HET when considered by the Committee of Ministers. But it also shows, as I say, this trend of weakening safeguards. And so what one sees, for example, in that is a number of factors identified. The removal of ring fencing of financing, an issue that is obviously of real importance given the point I already made about the resources available. The removal, linking into the point that the HMIC made, of direct reporting from the chief to the chief constable. That's para 39. The removal of outside staff controlling legacy investigations, para 41. the removal essentially of arrangements for carrying out legacy investigations by HET, which included obviously potentially bodies such as the White Team, which meant essentially if the LIB were to conclude that there was a basis for investigation, it would then be conducted internally by PSNI, and sees that para 47. No basis for believing that the cross-referencing database that allowed effectively investigations material from one investigation to be used in another investigation was being updated. And as I already indicated, that's 49, and as I've already indicated, 54, the White Team being ended. And all of that fits in with the points I've already made about, in particular, intelligence being still not verified outside Northern Ireland. I should reference as well, I won't take you to it given the passage of time, Mr. Justice Tracy's judgment, which was in similar terms, looking at these changes, which is electronic 10219, paragraph 130 onwards, which concluded, and I particularly emphasise the conclusion at paragraph 209, that it was a matter of grave concern that steps had been taken to dismantle the principles put forward to the Committee of Ministers to achieve compliance with Article 2. Sorry, my Lord, Lord Hamlin, I think, has a question.
Yes, thank you. Where and how is this commentary carried through into the Court of Appeal's conclusions on independence?
Well, my Lord, in my submission, the way it's carried through to the Court of Appeal conclusion is that where the Court of Appeal at para 193 look at essentially the specific issue of independence, it looks at, for example, at para 196, the extent of a hierarchical connection essentially between the Chief Constable. It looks at the absence of the White Team, and so it's putting what the Court of Appeal in my submission is doing is essentially taking this as context and putting that together with the particular investigative failures rather in the McQuillan case at 198. So it's effectively linking this material into with the particular facts of the case to reach a conclusion that applying the test it set itself, which was a high threshold to sort of conclude a lack of independence at this stage, that test was met. Well, I hope that answers my Lord's question.
Right, so general context rather than specifically following through any of these particular findings.
Well, when my Lord says general context, well, I would put it slightly differently, perhaps, in the sense that I would say what the court is doing, consistent with Tunk, is saying you need to look at everything together, and so it's looking at the institution with the failings in the past. And it's doing essentially what it's required to do, which is to look at everything, which is also, we would submit, consistent with the fair-minded bystander, which is to say, look at the fair-minded bystander is, of course, the informed bystander, and the informed bystander takes account of everything that's relevant. My Lord Burrows, I think, has a question for me.
Yeah. Do I understand your answer to those questions to mean that you are interpreting the Court of Appeal as having decided that there were institutional, a lack of institutional independence, as well as a lack of practical independence?
No, what I would say the Court of Appeal did, which to some extent is consistent with Tung, is it recognised the institutional issues here, but looked at also the specific issues that arose in this case, the investigative failures, and ended up with the conclusion essentially that taking account of that background and what had occurred in the case, there was a lack of practical independence.
So you're saying there wouldn't have been a finding of practical independence without this background institutional problem?
it's always very, I mean, I don't know what the court would have made of that, because of course,
well, let me put it this way. My reading of the Court of Appeal at the moment is that they are making a finding about practical independence alone.
Yes.
And that one has therefore got to be very careful in applying these notions, not to conflate or mix them up. And therefore, I'm finding the commentary earlier on in the judgment of the Court of Appeal actually somewhat peripheral, because it seems to me that in their conclusions, they're effectively saying, we are satisfied there was sufficient institutional independence, so that all that commentary, actually, they've looked at it, but what they're saying is, it makes no difference because there is sufficient institutional independence. And that what they're then saying is, however, we're not satisfied with practical independence. Yeah, am I wrong to interpret it in that way?
I would say it is a combination of that it's part of the context, effectively, that what the court is. I'm looking also at para 197, essentially. What the court is doing is looking at practical independence in the context of what is known about PSNI, or perhaps more importantly, LIB as an organisation. And we've said in our written case that we would submit that the European Court refers to hierarchical, institutional, and practical independence in some of its judgments, a number of its judgments, but one can't necessarily regard those as rigid demarcations. And Tunk itself indicates that where you've got a structural issue, that may mean you need to look with greater care at the particular issues that arise in a case. And that's, in my submission, what the Court of Appeal is essentially doing. Lord, look at the time. I just need to.
Sorry, I have to say, I read the Court of Appeal's judgment the same way as Lord Burrows. And what was striking about Mr. Justice McGuire's judgment is that he didn't make clear whether he was talking about institutional hierarchical independence or practical independence. And the Court of Appeal has interpreted him as saying it's a question of practical independence. The Court of Appeal has said there is the necessary hierarchical and institutional independence, and the focus therefore is on practical independence. I have to say that is my reading, and I'm not entirely clear what your position is as to how the institutional elements that were recited earlier in the judgment fit into the eventual judgment on practical independence.
Well, as I say, I'm not sure I can say more than to say that if one looks in our submission at paras 196 to 198, 199, we accept that what the Court of Appeal find, obviously, is that there is a lack of practical independence. But we would submit that it's informed to some extent by, and indeed this is, we understand, a criticism made by my learned friend, it's informed to some extent by the background, and in our submission that is entirely consistent with Tunk. Yeah. I mean, I should say that our position would be, in any event, that there is a lack of institutional independence given those issues in certain state, or in cases that involve state allegations against the state. But I don't need to go that far. I need to defend the judgment I have. I mean, the material I've identified in our submission does undermine the position in particular of LIB.
Just to be clear, Mr. Southey, you say you don't need to go that far. As I understand it, you're not making that submission to us. We don't need to deal with that separately.
We put in writing that that's our position, but of course, ultimately, what you're concerned with essentially is whether or not the Court of Appeal was entitled to find what it did. And I accept that the Court of Appeal's finding is case specific, because even on my reading of it, it involves taking account of past failings, and indeed it involves taking account of past failings in both cases. In the hooded men, there is reference to the past failings. Given time, and I'm very conscious of the time, I'm not going to take you through the details of the investigation, the investigative failures. All I would highlight in relation to the McQuillan case is that it is clear, effectively, that there were concerns being raised about the military as early as 1973. You've heard reference to the Belfast Telegraph article. No one looked at the military logs or the material that was relevant to the military, as far as anyone's aware, until an independent investigator looked at that and drew it to the family's attention. It was left effectively for the family to find out what was in the military logs when they were made public. The reason for that was considered by Mr. Justice Maguire, and his reasoning was upheld by the Court of Appeal. And he looked at the reasons, indicated he couldn't essentially determine what the reasons were, but as I've already indicated that both in relation to the investigation by the RUC and also the investigation by PSNI's HET, there was the potential for non-benign reasons. And that was obviously hugely relevant to the extent to which a PSNI body should carry out further investigations. And what is striking, I recognise the dangers of relying on fresh evidence, but what is striking is that if fresh evidence does go in, one has material at 10348 from Mr. Boucher, who is now conducting the investigation, an English police officer, the former Chief Constable of Bedfordshire, demonstrating a completely different and much more intense investigation of the circumstances of the death. As I say, the letter from the Crown Solicitors agreeing to a further investigation is at 2015. I won't take you to it again because of time, it's 1310. But the critical point about that is, firstly, it only undertook to investigate in accordance with the case sequence model. That means one has no idea when that investigation would take place. And it discounted the involvement of the MRF, even though Mr. Boucher, unsurprisingly, is investigating that. In relation to the hooded men, I'm going to leave my learned friend Ms. Quinlivan to deal with the response of PSNI. But clearly, courts at High Court level and Court of Appeal level both found that there were inadequacies, and that fed into the approach to independence. And we would also, in relation to independence, highlight the fact that the decision was taken to pause the work of Mr. Boucher. That, in our submission, also feeds into public confidence. So, in our submission, going back to the Court of Appeal was entitled to conclude in the McQuillan case, taking account of the failures that had occurred in that case, there was a lack of independence. The Court of Appeal was entitled to express doubts about the independence of hooded men in circumstances where, again, it took account of the failures. The key Roman, I think it's Roman 9 of paragraph 116, does that. Whether it should have waited for a further investigation in our submission, in our submission, there's no basis for saying it should have waited for a further investigation. If one accepts, as we submit, that it is clear that ultimately the issue is in part linked to public confidence. If the arrangements are such that it's possible for the court to conclude essentially that the arrangements are inadequate, in our submission, there cannot be any reason why someone is required to wait. Indeed, my learned friend accepts there may be circumstances where it's appropriate to bring a claim early on. What the Court of Appeal did in this case was set a relatively high threshold. We wouldn't necessarily accept that the threshold was set in the right place. It required a compelling case that current arrangements are inadequate. But if one can show that current arrangements are inadequate, why require further delay? And particularly given the importance of avoiding delay in Article 2. The approach we would submit to the Court of Appeal is also consistent with the approach adopted by the English Court of Appeal in Baha Musa. I'll give you the reference again because of time.
Mr. Southey, I've been allowing you to run on a bit, but you do remember that we have a mid-morning adjournment.
I'm very sorry, my lord.
I think you seem to have lost sight of that.
Yes, no, I completely lost sight of that. I admit I completely lost sight of that.
Yes. Well, would this be a convenient place for us to have that adjournment? Or do you wish to, or are you about to complete a section?
I was going to give a reference, and I would probably have 2 minutes left, my lord. So
complete that submission, and then we'll take the break. Okay.
Yeah, my lord. All I was saying was that the English Court of Appeal making the same point was Baha Musa, which is page 4335. Again, recognising one shouldn't have to wait, and that's paragraph 41 and 46. There are two very short points I wish to make. I'm conscious of the time, but obviously we need to break, basically, and I'm sorry, my lord, for forgetting that.
You wanted to do those two short points now?
Yes, my lord, that would probably make...
But Lord Sales has a question to ask you.
Yes, sorry, Mr. Southey. Just on the Baha Musa,
yeah,
looking at paragraph 41, that's, correct me if I'm wrong, but that seems to be an institutional lack of independence problem with the IHAT. Is that not right?
But the fundamental point it was making in our submission was that if the arrangements that are in place can be shown to be inadequate at this stage, then why should you have to wait? And that's effectively what the Court of Appeal we would submit was deciding in McQuillan.
Yeah, but doesn't it make a difference whether one's dealing with an issue of institutional independence as opposed to practical independence? Because if the problem is institutional independence, you can say of that institution now, it ought not to be the investigator. But if it's practical independence, that may depend upon specific events that happen in the course of the investigation, and you can't tell necessarily now that there will be a problem with that.
Well, my lord, if ultimately practical independence has to be assessed in the light of public confidence, one can potentially say the arrangements that are in place, taking account of matters such as the history of the investigation in this case, are not adequate to ensure public confidence.
Right, but anyway, I was just asking your assistance on a point of information.
Yes.
Is the Musa case concerned with a problem of institutional independence in relation to the IHAT?
Yes. Yes.
All right. Thank you.
Well, the two short points I was going to make was just, in terms of previous judgments, particularly Brecknell, we would submit that in relation to Brecknell, it's quite clear that the European Court of Human Rights had nothing like the level of information that the Court of Appeal had, and in particular was simply focused on one issue, which wasn't in fact argued before it apparently, which was whether or not in particular the HET, I think it was institutionally independent. Kelly and Hackett, as the Court of Appeal made clear, paragraph 199, were concerned, in fact, whether the sorts of arrangements that we're arguing for, which is an external officer, were put in place. Finally, just in terms of, my learned friend, Ms. Quinlivan, is going to deal with delay, just in terms of the procedural point, to be clear, The point we make about the procedural point about delay is, firstly, in the hooded men case, and it only arises in the hooded men case, there was an appeal, a cross appeal, detailed cross appeal. No one pleaded in the grounds effectively delay as being an issue. Secondly, and probably more importantly in some senses, in any event, one of the reasons we raised this issue is it wasn't raised at JR leave stage. And of course, where delay is going to be raised, CX Party A, page 6505, it should be raised at leave, essentially. Lord, I apologise again for slightly overrunning, and in particular for getting the morning break. But that, I think, concludes what I have to say.
Yes, well, Mr. Southey, I'm not sure I know whether or not you've overrun, because the timetable simply refers to respondents cross appellants, and doesn't precisely divide the time among you.
Well, my lord, I think I was meant to finish at 12 o'clock, but I was meant to provide a break. So on the agreement between us, and I'd completely forgotten about the need for a break, and that's where I think I failed.
Yes, well, your timetable may not tally with the one that I've been given, but in any event, we will take the break now and resume in 5 minutes' time. Thank you very much.
Thank you.
I think we're now ready to resume. Mr. Southey, thank you very much for your submissions. Ms. Quinlivan, can I just ascertain the proposed timetable? You're intending to speak till when?
My lord, the original timetable had indicated that I would start at 11:45 and finish at 2:30, so allowing an hour and 45 minutes. So I was going to take that as my allotted time, and that had been discussed this morning between the parties. I don't think there's any issue about that. I think any loss we've made will be taken up in replies.
Yes. So the agreed position is you speak till 2:45.
I think that's right. Yes.
Well, that's fine. Thank you very much.
Thank you. My lords, I will be addressing your lordships, firstly on the issue of convention values in the context of the hooded men case, and secondly on the respondents' common law claims in the hooded men case. And on this issue, on the latter issue, our arguments are threefold. Firstly, that the Court of Appeal was correct to conclude that the statement made by the Chief Constable to the Northern Ireland Policing Board created a legitimate expectation that the investigation to be conducted would be aimed at identifying evidence of criminal behaviour. And the Court of Appeal is correct that the Chief Constable has not resigned from that undertaking, and the applicants / respondents continue to have a legitimate expectation. Secondly, as per the judgment of Mr. Justice Maguire, affirmed by the Court of Appeal, the investigation conducted was unduly narrowly focused, and the police approach to the investigation was irrational. In our submission, the investigation was properly quashed, and the respondents' legitimate expectation remains unfulfilled. And thirdly, the conduct of the police investigation demonstrated, as the Court of Appeal included, apparent bias and lacked independence in the manner in which it was conducted. And this raises real concerns about the independence of the police service in Northern Ireland going forward. My lords, on the issue of convention values, we invite your lordships to endorse the judgment of the High Court. Mr. Justice Maguire addresses this issue, and I don't take you to it for present purposes, but it's at electronic pages 2020 to 2021, paragraphs 247 to 258 of his judgment. As your lordships know, the Court of Appeal didn't reach a concluded view on this issue, and that was in light of their decision that the Brecknell trigger hadn't been met. They addressed the issue at electronic page 1924 in paragraphs 108 and 109 of their judgment. My lords, the convention values test which was addressed in Janovich was foreshadowed in the judgment of Chile and Slovenia. and your lordships will find that judgment, which I'm going to take you to briefly, at 5356, my lords, and your lordships have already had opened to you paragraphs 162 and 163 of that judgment. And my lords, if in examining the procedural obligation, if I can summarise, at 162, the court will only look at procedural acts or omissions which occur after the critical date. And at 163, the court identifies the need for a genuine connection, a term which has caused some difficulty. And then, my lords, if I could just indicate that over the page at 5357, the first formulation of the convention values test is that the court would not exclude that in certain circumstances the connection could also be based on the need to ensure that the guarantees and underlying values of the convention are protected in a real and effective manner. Janovich then addresses this issue, and your lordships will find the relevant, the start of this discussion at electronic page 5092. I'm conscious that your lordships have already been taken to paragraphs 149 and 151, but I was going to invite your lordships to look back at the section entitled The Clarification of Shilley. There's a discussion at paragraph 141, your lordships will see, which essentially replicates the judgment in Shilley. And then, my lords, there's a discussion at 142. You'll note the court says that the procedural obligation to investigate is not a procedure of redress in respect of an alleged violation of the right to life that may have occurred before the critical date. It consists in the lack of an effective investigation. It has its own distinct scope of application and operates independently from the substantive limb of Article 2. And then, my lord, the court goes on to deal with the concept of acts and omissions, procedural acts and omissions, which were referred to in the Shilley judgment. At 143, the court expands on its explanation of procedural acts, and it says that it's looking at acts undertaken in the framework of criminal, civil, administrative or disciplinary proceedings which are capable of leading to the identification and punishment of those responsible or to an award of compensation to the injured party. And of course, they discount inquiries which may be carried out for other purposes, such as establishing a historical truth. My lords, we will say that the investigation promised but delivered by the PSNI, we say in a completely inadequate manner, represents procedural acts of the type described in 143 of Janovich. And to quote the Court of Appeal, the investigation, the police investigation, ought to have been aimed at identifying criminal behaviour, and thus we say it falls within the definition of paragraph 143 of Janovich. And my lords, for your assistance, the quote from the Court of Appeal that it ought to have been aimed at identifying criminal behaviour can be found at electronic bundle 1924, and it's the final sentence of paragraph 112. And then paragraph 144 deals with the issue of omissions, and essentially for our purposes, it includes investigations which ought to have occurred because there is a Brecknell trigger, and Mr. Sully has already addressed you as to how that threshold has been reached in this case, and I obviously don't repeat that. So we say there were procedural acts within the meaning of paragraphs 143, and that the Brecknell test is met within the meaning of paragraph 144. We don't address you on genuine connection, but my lords, if you're against us on the genuine connection test, we say nonetheless, if the convention values test is met, then Articles 2 and 3 are engaged in the facts of this case. My lord, Janovich then goes on at 149 to outline the application of the test. and your lordships will find that at electronic page 5094. And it states, the court accepts that there may be extraordinary situations which do not satisfy the genuine connection standard, but where the need to ensure the real and effective protection of the guarantees and the underlying values of the Convention would constitute a sufficient basis for recognising the existence of a connection. And they consider that Janovich was a case which on the facts could fall into that category. And then, my lord, at 150, they say the reference to the underlying values of they understand the reference to the underlying values of the Convention to mean that the required connection may be found to exist if the triggering event was of a larger dimension than an ordinary criminal offence and amounted to the negation of the very foundations of the Convention. And my lords, I'd ask you to note, in terms of looking at this test, they say this would be the case with serious crimes under international law, such as war crimes, genocide, crimes against humanity. But my lord, we invite you to have regard to the face, this would be the case. It follows, we say, that the Convention values is not limited to that category and those definitions which follow. So it's not limited to crimes against humanity, genocide. If it was, the court would have said so. And what you have is a definition which encompasses, on the one hand, as it's outlined, a triggering event of a larger dimension than an ordinary criminal offence, going through, as it were, to even genocide and crimes such as genocide and crimes against humanity. And of course, at 151, the court makes clear that even genocide, even crimes against humanity, will be excluded if they predate the Convention. Essentially, what they say is there was no Convention, there are no Convention values, and that represents the only temporal limit if we meet this particular threshold. My lords, we accept that the classification of the conduct meted out to the hooded men is relevant to this issue, and your lordships will be aware, obviously, of the issue. The court in 1972 concluded that the treatment was inhuman, and you'll know the Court of Appeal stated that, looking at this matter through the prism of current day values, that the treatment constituted torture. And my lords, it is our submission, firstly, that this court can properly conclude that the treatment inflicted on the men is properly to be characterised in June 2021 as torture, and that is torture within the meaning of the Convention and torture at common law. And it is our contention that this court should state unequivocally that the treatment to which the men were subjected at the hands of a police force of this state, based upon training given to that police force by the army of this state and on the instructions of government ministers of this state, amounted to nothing less than torture. My lord, in the case, and looking at this issue, in the case of Mrs. McKenna, who I represent, the daughter of Mr. McKenna, who was one of the hooded men, your lordships will have seen, and I don't open this to your lordships, but it's relevant, obviously, to the question of torture. It's electronic bundles 2151 to 2152, which is Ms. McKenna's affidavit. The relevant paragraphs are paragraphs 11 to 14. The salient points are that Mr. McKenna was released from internment on medical grounds in order to enter a psychiatric hospital. He essentially remained in the care of a psychiatric hospital until his death on the 5th of June 1975, and your lordships have been taken to Dr. Lay's observations in relation to the fact that this man was medically examined before the torture was inflicted. His medical condition was noted, and nonetheless that treatment continued, and Dr. Lay was essentially, we say, satisfied that it contributed to his death. My lords, I propose to address your lordships firstly as to why we say Strasbourg and domestic authorities demonstrate that the treatment that the hooded men were subjected to would now and can now be characterised as torture. And that's in the context, my Lords, we acknowledge entirely of the Convention as a living instrument. My Lords, we rely on the following. The first relevant authority is Selmuni versus France. The relevant passages can be found at electronic bundle 9552 to 9553. My Lords, I am going to open those passages. They're also quoted in the A versus Secretary of State for Home Department case, which I propose to open in detail. So I don't invite your Lordships to particularly look at that at present. The key passage is paragraph 101. But my Lord, one matter I do wish to bring to your attention, because when one reads 1011 in isolation, it isn't apparent why it is that that passage is cited as authority for the proposition that the court has now moved to the point where the treatment meted out to the hooded men described in the Ireland versus the United Kingdom case can properly be characterised as torture. But if your Lordships look at the government submission, which can be found at electronic page 9551, at paragraph 94, my Lords, the government, the French government in that case, had essentially advanced a submission that the behaviour that was under scrutiny didn't constitute torture, and they advanced that submission on the basis of the court's case law. And the case law that's referenced in the footnote at paragraph 94, among others, is the Ireland versus the United Kingdom case. And it is in that context that the government submission was, the treatment in this case isn't torture because in Ireland versus the United Kingdom it wasn't torture. And that is essentially rejected, we say, by the court, which says that the convention is a living instrument, and what we've previously said doesn't constitute torture. It doesn't constitute torture, but it constitutes inhuman treatment. We now form the view that it constitutes torture. My Lord, the second authority we rely on in support of the proposition that looked at through today's lens that this treatment constitutes torture is the judgment of Lord Bingham in A versus Secretary of State for the Home Department. Again, my Lords, I propose to open this judgment more fully and in due course, but to give you the references on this particular issue, he states at electronic page 4286, he states that it would be wrong to regard as immutable the standard of what amounts to torture. He then quotes the passages from Selmuni, that is paragraphs 99 to 101, and they can be found from 4286 through to 4287. And he says at 4287, it may well be that the conduct complained about in Ireland versus the United Kingdom would now fall within the definition in Article 1 of the Torture Convention. And my Lords, in the same judgment, Lord Hoffman also makes reference to the treatment meted out to the hooded men in Ireland versus the United Kingdom. You can find his treatment of the issue at electronic page 4297 to 4298. That is paragraph 97. And he states that he would be content for the common law to accept the definition of torture which Parliament adopted in section 134 of the Criminal Justice Act 1988, namely the infliction of severe pain or suffering on someone by a public official in the performance or purported performance of his official duties. And he states that would, in my opinion, include the kind of treatment characterised as inhuman by the European Court of Human Rights in the United Kingdom, but not all treatment which that court has held to violate Article 3. So again, he's making this distinction between what was found to be inhuman treatment in the hooded men. He thinks that now meets what he would define as the common law standard of torture, but he's distinguishing the inhuman treatment reached by the hooded men to other cases in the Strasbourg body of case law where findings short of torture being made, and he's not necessarily including those within his definition of torture. And my Lord, the final judgment that we say supports our contention that the proper characterisation of this treatment as torture is the Ireland versus the United Kingdom revision judgment. And I do ask your lordships to open that judgment because it has been opened to you in the context of discussions around the Brecknell test and its implications for that test. But my lord, it raises different issues in relation to this particular issue. My lord, the first reference I wanted to give your lordships to put the matter in context is the electronic page 5005. And my lord, paragraph 20, it simply outlines the Irish government's formulation of the issues before the court. And we're concerned with the first limb of the Irish government's application rather than the second limb of the Irish government's application. And their case was that the respondent government, the UK government, had information within its possession, including medical reports from Dr. Lay, demonstrating that the effects of the 5 techniques could be substantial, severe, and long-lasting. And what it said that this was in circumstances where the United Kingdom government, through the evidence of the self-same doctor, had alleged in the convention proceedings that the effects were minor and short-term. So that was the argument being advanced, and your lordships, I think, will be aware that that's in the context in particular, but not exclusively, of Dr. Lay's reports in relation to Mr. McKenna. The documentation that is relied upon can be seen at paragraph, with the submission, sorry, the Irish government submission can be found at electronic page 5008, paragraph 27, and it says the government's view was that the new documents showed that the evidence given by Dr. Lay was misleading. It was at variance with his own contemporaneous findings based on the examination of some of the internees who've been subject to the 5 techniques. And the government's case has had the Commission and the court been aware of these findings, they would have concluded that the unanimous available expert evidence was that the suffering inflicted by the application of the 5 techniques was intense, that it often produced long-term effects, and they say it was difficult to see how the original court could have reached the conclusion it did on the intensity of the suffering caused by the 5 techniques. At the very least, the newly discovered documents might have had, and this is the Strasbourg test, a decisive influence on its conclusion. My lords, if I can then ask your lordships to look to electronic page 5026, and I don't need to open it to your lordship, but paragraphs 108, 109 and onwards, they identify the documents which the government relied upon in support of their first ground. And then, my lord, over the page, I'd ask you to note simply the observation the court makes at paragraph 113. Having reviewed the documentation provided by the Irish government, which is set out above, the court said they had doubts as to whether the documents submitted by the applicant government contained sufficient prima facie evidence of the alleged new fact, namely that Dr. Lay had misled the Commission as to the serious and long-term effects of the 5 techniques. So essentially, they find against the government at the first limb, so to speak, but they do go on to, if you go to electronic page 5028 at 19, they're prepared to assume that the documents establish the new fact, and then they explain the test that they're going to apply at paragraph 121. They say, in order for the revision to be granted, it must be shown that there was an error of fact and there must be a causal link between the erroneously established fact and a conclusion which the court has drawn. In other words, it must be clear from the reasoning contained in the original judgment that the court would not have come to a specific conclusion had it been aware of the true state of facts. And then, my lords, over the page at E5029, they address the issues from paragraph 122 onwards. They, at 122, reiterate the importance of legal certainty and state that as a consequence, requests for revision are subject to strict scrutiny. The court will only proceed to the revision of a judgment where it can be demonstrated that a particular statement or conclusion was the result of a factual error. And at the conclusion of that paragraph, they say, where doubts remain as to whether or not a new fact actually did have a decisive influence on the original judgment, legal certainty must prevail and the final judgment must stand. They then say they will examine whether there's a basis in the reasoning, and so they go back to the original judgment that warrants the conclusion that the court would have qualified the use of the 5 techniques as amounting to a practice of torture within the meaning of Article 3 had it been aware of the facts alleged by the applicant government. And they do point out at 124 that the long passage of time between the delivery of the original judgment and the submission of the revision is obviously irrelevant. And then they say, my lord, and we say this is important from the point of view of our contention that what we are looking at now was torture. They say during that lengthy period, that's the passage of time between the original judgment and the research coming from the UK archives, during that lengthy period, the case law on the notion of torture has evolved. Most notably in Salmooney at 94 and 100 to 105, the court dismissing the government's argument relying on the judgment of Ireland versus the United Kingdom, the original judgment, that the ill treatment inflicted on the applicant did not amount to torture, stated that certain acts which were classified in the past as inhuman and degrading treatment as opposed to torture could be classified differently in future. And they further say, while the effect of the treatment on the victim was at the time of the original judgment one of the elements to be considered, explicit references to the relevance of long-term effects of a treatment when distinguishing between torture and inhuman treatment only appear in the court's subsequent case law. And they reference the case of Egmas, a 2002 case, and Gafgen, a 2011 case. And they say the court therefore has to be careful when examining whether the alleged new facts had a decisive influence on the original judgment, and they reference the wording of Rule 20. They say a request for revision is not meant to allow a party to seek a review in the light of the court's subsequent case law. And my lord, what we say flows from that judgment, we say unambiguously, is that it is now clear, and it's clear from the revision judgment, that the threat that the treatment, classified in the original Ireland versus the United Kingdom, which was classified as inhuman treatment, ought now properly be classified as torture. And we say there is no doubt about that. That's not to say that the original judgment is overturned or revised. Clearly that's rejected for reasons of legal certainty and for the reasons that the court concluded. But that doesn't alter the strength of the proposition that, looked at through the prism of today, and indeed looked at through the prism of the timing of Salmooney, that treatment is properly to be regarded as torture. So, my lord, we say that's the first important aspect of the case we wish to establish, which is the treatment should be regarded as torture. My lord, we then rely on the judgment in particular of Lord Bingham in A versus the Secretary of State for the Home Department. My lords, I'm sure it's no revelation to any of your lordships, given the seminal nature of this judgment, that the court concluded that the common law historically has prohibited torture. But the reason that I'm opening aspects of the judgment is because in my respectful submission, Lord Bingham's judgment expresses much more eloquently than I could why the systemic infliction of torture by law enforcement personnel with governmental sanction is of a significantly larger dimension than ordinary criminal offences and amounts to a negation of the foundations of the Convention. My lords, I'm going to essentially, I'm conscious of issues of time, I'm going to select and highlight portions of the judgment. Your lordships will obviously wish to read the judgment more carefully than I necessarily open it. And I apologise if anyone thinks I'm taking too many shortcuts. The relevant starting point from my perspective is at electronic page 4261. And my lord, at the outset, Lord Bingham at 10 notes the appellant's submission that the common law forbids the admission of evidence obtained by the infliction of torture. And at 11, Lord Bingham says at C, and I don't propose to read the entirety of this passage, but to identify certain aspects of it. He notes that it is clear that from the very earliest days, the common law of England set its face firmly against the use of torture. If your lordships move down that paragraph to E, he observes that the English rejection of torture was also the subject of admiring comment by foreign authorities. And then, my lord, if one looks at what he states at G, he says, and he quotes from the publication on the judicial use of torture, he said, in rejecting the use of torture, whether applied to potential defendants or potential witnesses, the common law was moved by the cruelty of the practices applied to those not convicted of crime, by the inherent reliability of confessions or evidence so procured, and by the belief that it degraded all those who lent themselves to the practice. My lords, he then observes in Jardine's words at the top of page 4262 that common lawyers regarded torture as totally repugnant to the fundamental principles of English law and repugnant to reason, justice and humanity. And my lord, we say that language could easily be converted in modern day parlance to undermining the convention values of the Strasbourg Convention. My lord, the next section of his judgment, which commences at 4263, deals with the issue of involuntary confessions. I appreciate we're not in that territory, but if one looks at 4264, quoting from the judgment of Lam Chi Ming versus the Queen at paragraph 17 and a D, and this is, I accept, in the context of improperly obtained confession, but their lordships were of the view that the more recent English cases established that the rejection of an improperly obtained confession is not dependent only upon possible reliability, or also upon the principle that a man cannot be compelled to criminate himself, but for present purposes, the passage I relies upon, and that is the importance that attaches in a civilized society to proper behaviour by the police towards those in their custody. And my lords, you'll note some of the references he gives further down the page to other common law countries. He refers to, I'm sure I'm pronouncing this wrong, the Roshan versus California. I note the date of the decision, my lords, 1952. It's between F and G of that passage of the judgment. A conviction obtained by conduct that shocks the conscience, and he talks about states and their prosecutions respect certain decencies of civilized conduct. An Irish case, further in the case, he said that the authority in the Due Process Clause of the United States calls for judgment whether these proceedings offend canons of decency and fairness, which express the notions of justice of English-speaking peoples, even towards those charged with the most heinous offences. And then he refers to a decision of a judgment of the Irish Supreme Court from 1965, which indicates that to countenance the use of evidence extracted or discovered by gross personal violence would, in my opinion, involve the state in moral defilement. My lord, it's the language used, we say, that is significant in terms of the discussion, my lords. If one moves then to electronic page 4270 and simply observe, my lords, that this is under the heading, you'll see it at 4269, this is under the heading Public International Law. And my lords, I think I should acknowledge, because I've just appreciated, this is a summary of the appellant's arguments rather than the judgment of the court, but the court does later confirm, I think over the page, that the prohibition of torture enjoys, this is, my lords, a paragraph 28.2, the prohibition of torture enjoys the highest normative force recognised by international law. And the international prohibition of torture requires states not merely to refrain from authorising or conniving at torture, but also to suppress and discourage the practice of torture and not to condone it. My Lords, I'm then going to use this opportunity because Lord Bingham's surveys the legal landscape in terms of torture in a truly comprehensive way. If one looks at paragraph 4271, or sorry, electronic page 4271, it references the fact that the Strasbourg Court has in its decisions invoked a wide range of international instruments, and they then reference the Torture Convention, and they then quote from a case. My Lords, I hope this authority was made available to your Lordships in full this morning. That's the case of Searing versus the United Kingdom, and he quotes from the judgment of the Strasbourg Court in that case. He notes that Article 3 makes, and this is the judgment of the Strasbourg Court, Article 3 makes no provision for exceptions. No derogation from it is permissible under Article 15 in times of war or other national emergency. This absolute prohibition on torture and on inhuman, degrading or treatment shows that Article 3 enshrines one of the fundamental values of the democratic societies making up the Council of Europe. It is also to be found in similar terms in other international instruments. And then, my Lord, in Searing, they go on to discuss the question which was before that court, and that was about the extradition of someone who, if extradited, would be likely to be subjected to torture or inhuman, degrading treatment or punishment. And the Strasbourg Court recognises that the abhorrence of torture has such implications that it's recognised in Article 3 of the UN Convention Against Terror, Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, which provides that no state party shall extradite a person where there are substantial grounds for believing that he would be in danger of being subjected to torture. And the court goes on to state, the fact that a specialised treaty should spell out in detail a specific obligation attaching to the prohibition of torture does not mean that an essentially similar obligation is not already inherent in the general terms of Article 3 of the European Convention. And my Lord, I ask your Lordships to note the next sentence. It would hardly be compatible with the underlying values of the Convention that common heritage of political traditions, ideals, freedom and the rule of law to which the preamble refers were a contracting state knowingly to surrender a fugitive to another state where there were substantial grounds for believing that he would be in danger of being subject to torture, however heinous the crime allegedly committed. And my Lord, the language underlying values of the Convention clearly finds its direct reflection in the submission that we make to your Lordships today. And we invite your Lordship to have regard to the language of the preamble and say to your Lordship that the treatment to which the hooded men were subject to is not compatible with the underlying values of the Convention. It is not compatible with that common heritage of political tradition, ideals, freedom and the rule of law to which the preamble of the European Convention on Human Rights refers. My Lords, if I can then ask your Lordships to look to electronic page 4284. And at paragraph 51, the context and the discussion, my Lord, is in the context of the Secretary of State's case. You'll see the heading at 4283. Paragraph 51 is at the bottom of the page, and I'm really only looking to the last sentence and Lord Bingham's finding that the English common law has regarded torture and its fruits with abhorrence for over 500 years. That abhorrence is now shared by over 140 countries which have acceded to the Torture Convention. Over the page at 4285, it's within the same paragraph, 51. It's at E on the right-hand side, and Lord Bingham states that it trivialises the issue before the House to treat it as an argument about law of evidence. The issue is one of constitutional principle. And he then states at 52 that he accepts the broad thrust of the appellant's arguments on the common law. The principles of the common law, standing alone, in my opinion, compel the exclusion of third-party torture evidence as unreliable, unfair, offensive to ordinary standards of humanity and decency, and incompatible with the principles which should animate a tribunal seeking to administer justice. And he goes on to say that the principles of the common law do not stand alone. Effect must also be given to the European Convention, which in its place takes account of the universal consensus embodied in the Torture Convention. And my Lord, if I could then finally, I want to acknowledge, my Lord, I think it's important to do so, given the finding of the original court in Ireland versus the United Kingdom. One of the submissions advanced by the appellants in that case, you'll see this at paragraph 53, they broadened their argument to contend that all the principles on which they rely apply to inhuman and degrading treatment if inflicted by an official with the requisite intention and effect as to torture. That argument is rejected by Lord Bingham. And you'll find this at electronic page 4286. He states at D, the treatment falling short of torture may invite exclusion of evidence as adversely affecting the fairness of the proceedings. He says, but I do not think the authorities in the Torture Convention justify the assimilation of these two kinds of abusive conduct. Special rules have always been thought to apply to torture, and for the present at least must continue to do so. But then, and this is the passage I had referenced to your lordships earlier, he says it would on the other hand be wrong to regard as immutable the standard of what amounts to torture. He refers to Salmuni versus France. The relevant paragraphs are cited below. I simply refer, because I'd indicate I would do so, to paragraph 101, where it notes the court has previously examined cases in which it concluded that there had been treatment which could only be described as torture. However, having regard to the fact that the Convention is a living instrument which must be interpreted in the light of present-day conditions, the court considers that certain acts which were classified in the past as inhuman, degrading treatment as opposed to torture could be classified differently in the future. Increasingly high standard being required in the area of protection of human rights and fundamental liberties correspondently and inevitably requires greater firmness in assessing breaches of the fundamental values of democratic societies. So, my Lord, I acknowledge that this court makes a distinction between inhuman treatment and torture. My Lord, we say that distinction isn't relevant for the purposes of this case because we say, for the reasons outlined previously, that the treatment we're concerned with is torture. But I think it proper to draw that distinction to your lordship's attention. My lords, in looking at the issue of torture at common law and torture in Article 3 as undermining democratic values, I was going to invite your lordships to look at Lord Gardner's minority report in the Parker report. My lords, you'll find that document at electronic page 2533. My lord, and at 2533, my lord, Lord Gardner, and I don't need to take you through it, but he identifies in writing the procedures, the 5 techniques. At 2534, he notes in the second paragraph, he identifies the lengths of time to which the hooded men were subjected to this treatment. They range in periods from 9 hours, that is specifically the wall standing stress position, 9 hours to up to 43.5 hours. That's the range of time which the hooded men were subject to these proceedings. At 6, he said, and I ask your lordships to note this, I have thought it essential to state what the procedures referred to in the Compton reports were, because they were never published or even written down anywhere. We have been told that these procedures of interrogation in depth, namely hooding, a noise machine, wall standing and deprivation of diet and sleep, were never committed to writing in any directive, order, syllabus or training manual. They had been for some time orally thought for use in emergency conditions, in colonial type situations, at an army intelligence centre in England. He goes on to say that been used in Aden, but he says they do not appear from the report of Mr. Roderick Brown QC. It doesn't appear from his report that he ever discovered that these interrogation procedures were used there. My lord, I note the lack of a written record because can I respectfully submit that what it suggests and what it makes clear is that all of those involved in teaching these techniques and using these techniques understood that this shouldn't be written down because the conduct they were engaged with was reprehensible. It was both criminal and indeed certainly inhuman and in current parlance, torture. And the lack of documentary evidence, we say, is something the court will have regard to in terms of the state of knowledge of those who carried out this conduct at the time it was being carried out. They recognised that it should not be written down and recorded. I'd ask your lordships to note over the page 2535, Lord Gardner addresses the definition of brutality outlined in the Compton report, and he records that definition at the top of the page, and he makes the observation, lest by silence I should be thought to have accepted this remarkable definition, I must say that I cannot agree with it. He says, under this definition, which some of our witnesses thought came from the Inquisition, and he goes on to give an example of how he thought it could be used. My lord, we say his rejection of the definition is correct, and again is a recognition of how that approach undermines democratic values, the rule of law, and we say in current parlance and for the purposes of these proceedings, convention values. My lord, he observes, and I think your lordship have been taken to this at 2536 in paragraph C, he makes clear that the procedures were illegal alike by the law of England and the law of Northern Ireland. My lord, I should acknowledge, because it might be said that these sections could be argued against me, he deals with international law. He makes the point that it's been submitted the procedures involved infringement of the various convention articles which prohibit torture. If you go over the page 2537, he includes reference to Article 3 of the European Convention on Human Rights. He decides not to express an opinion on these submissions for a variety of reasons outlined at B on page 2537, which include that it may be open to argument which convention or conventions apply in Northern Ireland, that lawyers differ on the questions of construction. Words like torture and human and degrading treatment are clearly open to doubt. The procedures were admittedly illegal, and so he sees no purpose in discussing whether they were illegal by international law, and he references the case brought by the Irish government. And then, my lord, I simply ask your lordships to look at what he says at page 2542, paragraph 20. And this is a discussion because they're being asked to whether or not they can make a recommendation as to whether these procedures can be used subject to being regulated. At one, he states in clear terms that such procedures couldn't be used. He says he does not believe that such procedures are morally justifiable against those suspected of having information of importance to the police or army, even in the light of any marginal advantages which may thereby be employed. I don't repeat what he says at 2 or 3, save to note at the bottom of 3 that the medical witnesses from whom he heard, who were invited to discuss whether there could be some limits, some limited use of this treatment, they note at the very end, just above 4, no safe threshold can be set, and that's because of the differing abilities of individuals to withstand and cope with such procedures. And then, my lords, I'd invite you to look at what he says over the page, having reviewed why such techniques can never, in his view, be rendered legal or but by legislation. He says, for many years, men and women and a number of international organisations have been engaged in trying patiently to raise international moral standards, particularly in the field of human rights. He details the results: the Universal Declaration of Human Rights, the Geneva Conventions, the ICCPR, the European Convention of Human Rights. He quotes from the World Conference on Religion and Peace about their views on torture. and indeed the consultation of all Christian churches who also abhorred, for obvious reasons, torture. And he says there have been, and no doubt will continue to be, countries which act in this way, whatever conventions they have signed and ratified. We, as in we in the UK, have not in general been one of these. If by a new act of Parliament we now depart from world standards which we have helped to create, and again the resonance of that with the language of convention values, I believe we should both gravely damage our own reputation and deal a severe blow to the world improvement, to the whole world movement to improve human rights. My Lord, I've opened Searing versus the United Kingdom. And my Lord, our essential submission is this: what elevates this case to the status of a case engaging convention values is firstly the fact that the treatment can properly be described as torture. We say secondly the fact that this represented a deliberate policy, a decision at the highest levels of government, which involved training the police force, the RUC, by the military in techniques which had never previously been used in the United Kingdom. There is then the process of selecting multiple victims. They are selected by the RUC. Authority is expressly given by the Minister for Home Affairs, Mr. Faulkner. And this treatment is, of course, deliberately and systemically carried out by law enforcement agencies. My Lords, the assurances that you've been referred to, which were provided to the RUC in this context, are noteworthy. The RUC officer's defence to allegations of ill treatment was, we have been promised impunity in essence. We have been given assurances at high level. We have been promised impunity. And to use language in a different context, essentially the RUC were obeying orders. This is conduct which in our submission is repugnant to democratic values, it is repugnant to the rule of law, and it is repugnant to convention values. And your Lordships should find that the threshold of convention values has been met on the facts of this case. My Lord, I think that may be a convenient time, unless there's any questions arising at this juncture. My Lord, I can't hear my Lord Hodge.
I do apologise. Mr. Niven, there doesn't appear to be any questions, so we will take the short adjournment now and resume again at 2 o'clock. Thank you very much.
Thank you.